She had the land. She had the permits. She even had her tiny house fully built. 350 square feet of handcrafted perfection, sitting right there on her own property. And then a letter showed up. The HOA said, tear it down. She had 30 days. That story is not unusual. In 2026, it is becoming more common, because right now, nearly 80 million Americans live under HOA governance. That is approximately 30% of the entire U.S. population. And a huge chunk of those HOAs have rules on the books that can and will crush your tiny house dream before it ever gets off the ground. Today, I'm going to walk you through real stories, real dollar amounts, real legal fine print, and the specific things you absolutely must know before you buy land, build a home, or sign anything in an HOA community. Stay with me until the end, because I have a checklist of questions you must ask before you ever sign on the dotted line. That section alone could save you tens of thousands of dollars. Trust me on that one. Before we dive in, if you're new here, hit that subscribe button. We cover tiny homes, alternative housing, and real builds with real numbers on this channel. No fluff, no fairy tales, just honest information. Hit the like button too if you want YouTube to show this to more people trying to build smart. Alright, let's get into it. Let us set the stage with some real numbers, because this is bigger than most people realize. In 2024, 67% of all new single-family homes built in the United States were located in HOA-governed communities. That is up from 46% back in 2009. So if you're shopping for land or a new build, odds are better than 2 in 3 that you are walking into HOA territory. Now, pair that with this. The average HOA fee in 2026 runs between $350 and $500 per month for new construction communities. Fees have been rising 5 to 7% annually, driven largely by skyrocketing insurance costs. The older national average of $250 to $400 is still out there, but if you are buying into a community built in the last few years, budget for the higher end. That money is on top of your mortgage, your insurance, your taxes. And it gives the HOA the resources and the legal standing to enforce their rules aggressively. Here is the core conflict. The tiny house movement is growing fast. More Americans than ever are trying to downsize, cut costs, and build something affordable. But the majority of new housing stock is in communities specifically designed to keep housing large, uniform, and within a very specific aesthetic window. That tension is where the nightmares begin. The most common HOA weapon against tiny homes is not an outright ban. It is a minimum square footage requirement. Here is what that looks like in practice. A homeowner in a Florida suburb had her land. She had county zoning approval for a 350 square foot ADU to put on her property. Everything cleared, and then the HOA stepped in. Their CC&Rs. Those are the covenants, conditions, and restrictions that govern every HOA community. Required a minimum of 1,200 square feet for any new dwelling. Her 350 square foot unit was rejected. The county said yes. The HOA said no. The HOA wins. That is not a freak case. HOAs routinely enforce minimum square footage thresholds ranging from 1,000 to 2,000 square feet. A homeowner in Salt Lake County tried to place a 240 square foot tiny home behind their existing house. Technically allowed under local ADU rules, but was blocked by a 400 square foot minimum for accessory dwellings. Another Florida homeowner submitted full architectural renderings for a 320 square foot mother-in-law suite. Still denied. The CC&RS said nothing under 600 square feet and nothing resembling a trailer. Here is the legal reality that makes this particularly painful. HOA rules are legally binding as long as they comply with state and federal law. And minimum square footage, in most states, is perfectly legal for an HOA to enforce. You agreed to it when you bought the property. It is in the title documents. This is a big update worth highlighting. Now here is a case that actually ended with a win, and it matters for the entire tiny house movement. A Georgia woman named Cindy Tucker wanted to build tiny homes on her 8 acres of land outside Calhoun, Georgia. The city blocked her based on minimum square footage requirements. Even homes at 540 to 600 square feet did not qualify. She teamed up with the Institute for Justice and the Tiny Home Hunters United organization to fight back, arguing the ban violated the Georgia Constitution. In August 2025, the court ruled in their favor. Calhoun's ban on small homes was struck down as unconstitutional. That is a landmark win. It does not automatically change rules in other states, but it sets a powerful legal precedent and gives attorneys in similar fights a strong template to work from. Community members had literally shown up to those original city hearings and said they did not want lower-income residents moving in. The court effectively said that economic exclusion, dressed up as zoning policy, is not protected law. That argument is now part of the legal toolkit. Even if your tiny home clears the square footage threshold, you are not done. Most HOAs have an architectural review committee, called the ARC, that reviews any new structure or exterior modification, and they have enormous discretion. An ARC can legally reject your plans for the wrong roof pitch, the wrong exterior materials, the wrong siding color, or because the home does not visually match the primary house. One homeowner in Oregon was blocked over a home that hit 1,080 square feet, close to but under their HOA's 1,200 square foot threshold. The HOA argued it still did not comply, and the dispute went into a formal amendment process with no resolution in sight. Even garage conversions, one of the more HOA-friendly ADU options, require ARC sign-off. One attorney shared a case where homeowners were required to add 4 windows to their garage just to meet HOA appearance standards. The ARC can feel arbitrary, and in some cases it is. HOA enforcement is supposed to be uniform, and selective enforcement is legally actionable, but proving it is costly and slow. The insurance angle nobody talks about. Here is something your HOA board will almost never say out loud, but it is increasingly driving these rejections in 2026. It is not just about aesthetics. It is about the HOA's master insurance policy. In 2026, a growing number of insurance carriers are refusing to cover HOA communities if they allow non-traditional structures on site. Some boards are blocking tiny homes and ADUs simply because their insurance provider threatened to drop coverage for the entire neighborhood if they did not. That means your neighbors could end up uninsured because of your build, and the board is not going to let that happen. This is a real and underreported dynamic. When you talk to an HOA board about your plans, ask directly, does your master insurance policy have any restrictions on alternative or non-standard dwelling types? If they cannot give you a straight answer, assume the answer is yes. Let us talk about what happens when you proceed without approval. Because some people do. HOAs enforce their rules through a tiered system. Written warnings first, then fines, then liens against your property, and in serious or prolonged cases, foreclosure. Yes, an HOA can foreclose on your home for unpaid fines and assessments. That is legal in most states. California, AB 130, July 2025. California passed Assembly Bill 130 in July 2025, which caps most HOA fines at $100 per non-safety violation. Before this law, fines could compound daily into the thousands. The law requires the HOA to give you a chance to fix the issue and go through internal dispute resolution before escalating. But here is the loophole boards are already using: the health and safety exemption. HOAs are increasingly classifying tiny home violations, things like non-standard electrical connections or unconventional ventilation, as safety issues rather than aesthetic ones. That classification bypasses the $100 cap entirely. If your tiny home's wiring does not match HOA standards, expect fines well above $100 per day until you comply or remove the structure. Florida HB 1203, effective July 1st, 2024. Florida's major HOA reform went into effect July 1st, 2024. Under HB 1203, an HOA must send you written notice by certified mail before levying any fine, give you 14 days to respond, and provide access to a hearing with an impartial committee. They also cannot ban you from parking a personal vehicle in your own driveway. In 2026, the enforcement story has a twist. Many Florida HOAs are now being sued for failing to comply with the law's website transparency requirement. Communities with over 100 parcels were required to have a dedicated HOA website with full financial and meeting records posted by January 1st, 2025. Hundreds did not meet the deadline. If you're in a Florida HOA dispute right now, that non-compliance gives you legal leverage. Texas HOA updates, 2026. Texas updated its rules for 2026 as well. HOAs must now send certified written notice before any fine, give you a reasonable cure period, and maintain a written fine schedule. But Texas does not cap leasing fees or transfer fees. HOAs can still charge you significant amounts for rental-related activity, which matters if your tiny home plan involves rental income. A lot of tiny home enthusiasts think they have found a workaround. If they cannot build a standalone tiny home, they will build an ADU as a guest house or rental unit in the backyard. And in many cities and states, ADUs are being actively encouraged right now as a solution to the housing shortage. California, Oregon, Texas, and others have passed laws making ADUs easier to add. But here's where it gets complicated. An HOA can override local ADU-friendly zoning in many jurisdictions. If your HOA CC&RS prohibits secondary dwellings, require all structures to meet minimum size requirements, or ban short-term rentals, those HOA rules apply to you regardless of what the city or county allows. Most HOAs do not allow a tiny home or ADU to be used as a short-term rental, viewing it as disruptive to neighborhood character. Some may allow you to build one if it is never rented and blends architecturally with a primary home. But rental income from a backyard tiny house, blocked in the vast majority of HOA communities. And if you think you can get around all this by keeping your tiny house on wheels, most HOAs have explicit prohibitions on RVs, trailers, and temporary structures being stored or used on residential lots. A tiny house on wheels is classified alongside an RV in most jurisdictions. The HOA can tell you to move it off the property entirely. Here's the part that might give you some real hope. As of March 2026, HOA reform is on the legislative agenda in multiple states simultaneously. 7 states recently considered legislation allowing residents to keep farm animals, something most HOAs flatly ban. New Jersey introduced a bill allowing homeowners to vote to dissolve their association entirely. In Arizona, House Bill 2277, the so-called HOA Termination Act, is currently moving through the House Government Committee as of March 2026. It is one of the most aggressive pieces of HOA legislation in the country right now, and it is generating a real fight. Watch this one. On the energy front, bills targeting HOA restrictions on solar panels and EV chargers have moved forward in Arizona, Tennessee, New Mexico, Wisconsin, Ohio, and South Carolina. California already prohibits HOAs from banning solar installations under the Solar Rights Act. Why does this matter for tiny homes? Because the legal framework expanding homeowner rights in one area tends to bleed into others. If states are willing to say your HOA cannot ban solar panels, the next argument becomes, your HOA cannot enforce minimum square footages that have no basis in safety. That argument has not fully landed in legislatures yet, but it is coming. And homeowners in states with active reform environments, California, Florida, Texas, Colorado, have more tools to fight back than they did even 2 years ago. Okay, here's what I promised you. If you're considering buying land or property in or near an HOA community, here are the non-negotiable questions you need answered in writing before you spend a single dollar. Question 1. What is the minimum square footage for any new dwelling or accessory structure? The single most important question for tiny home builders. Get it from the CC&RS directly, not from the realtor, not from the seller, not from a verbal conversation with a board member. Pull the actual document from the county recorder's office or the HOA management company. Question 2. Does the HOA prohibit secondary dwellings, ADUs, or accessory structures? Even if local zoning allows ADUs, the HOA can block them. You need the CC&R language, not the zoning ordinance. Question 3. Where are the architectural guidelines, and who sits on the ARC? Ask for the full architectural standards document. Find out how ARC decisions can be appealed and how many members sit on the committee. Question 4. Does the HOA master insurance policy restrict non-traditional structures? This is the 2026 question most buyers never think to ask. Get the answer in writing from the board, not verbally. Question 5. What are the rental restrictions? If you plan to rent a tiny home, even to a family member, you need to know whether that is permitted, under what conditions, and whether short-term rentals are allowed at all. Question 6. What is the reserve fund status? Well-managed HOAs maintain reserves equal to at least 70% of their fully funded reserve calculation. Associations below that threshold are at risk of special assessments, surprise charges that can run $50,000 to $60,000 per unit in severe cases, particularly now that post-Surfside structural safety requirements are pushing communities to address deferred maintenance. Think about that number for a second. If you buy into an HOA to save money with a tiny home, one special assessment for a community pool you do not even use could cost more than your entire house build. The simplest piece of advice: if the HOA community has minimum square footage requirements above 600 square feet and no variance process, do not buy that land expecting to build small. Find land without an HOA, or find a community specifically built around alternative housing. So where can you actually build a tiny home without running into HOA walls? Rural land in states like Texas, Florida, Colorado, Oregon, and Tennessee offers the most flexibility, particularly in unincorporated counties with lighter zoning codes and no subdivision HOAs. Texas rural counties in particular often have no zoning or building codes at all outside major metro areas. Oregon treats foundation-built tiny homes under 400 square feet as legal dwellings and allows them as backyard ADUs. Florida's Sarasota County allows small builds without square footage minimums in select zones. Colorado's El Paso County has specific zoning provisions for tiny homes on wheels. Over 20 U.S. states have now adopted IRC Appendix Q, the specialized building code for homes under 400 square feet that relaxes certain standards. That is real progress. The golden rule: search for land in areas with the label No HOA. Then verify directly with the county planning and zoning office. Ask specifically, is there a minimum square footage requirement? Is this parcel in a subdivision with CC and RS recorded in the deed records? Can a tiny home under 400 square feet be permitted here? Get those answers in writing. Every time. The bottom line is this: HOAs are the single biggest legal obstacle most tiny home builders face. Not zoning, not building codes, not financing. Because while zoning laws and building codes are changing in the right direction, HOA CC and RS move much slower, and they are almost always enforceable the day you sign. The people in the stories we covered today did not fail because they had bad designs or bad contractors. They failed because they did not read the fine print before they bought it. You now know what to look for. Use that. If this video helped you, drop a comment below and tell me which story hit hardest, or share your own HOA experience. I read everyone. Hit subscribe if you want more honest content like this, and I will see you in the next video.